Today I'll be talking about Kant's legal theory and territorial rights. So there are some Kantian theories on offer in the current debate on territorial rights. So there is Anna Stilts, I'll be talking a little bit about her theory. There is Lea Ipi, Jeremy Waldron is also Kantian oriented. What I will be doing, because I am trained as a Kant scholar, I will be trying to reconstruct Kant's own position and draw a few conclusions from that reconstruction, because I believe that it's important not only for us to understand where our arguments come from, because even in the contemporary debate, we are drawing on the classical tradition on rights to territory, right? We are talking about Locke, we are talking about Kant, sometimes we're even talking about Hobbes, and so on. So this is important to understand where these arguments come from. But I also believe that revisiting the texts is very important, because sometimes there are certain motivations in these historical texts that we miss as contemporary readers of them. So it is very important to go back, I think, and rediscover them, understand their motivations, and then we can see if we can get something new, an alternative position that we can rediscover in these texts, or just understand where the limitations are, perhaps because they had, different concerns to us in our times. So we can see where the limitations are and where we should, as theorists, complement or go beyond these classical authors. So I think there's a lot to be gained there. So this is work in progress. I have been meaning to write on territorial rights for a long time, Kant territorial rights, but I just felt that I had to do a lot of background research on this first. So let me present what are my findings and my own conclusions. So the question is, why territorial rights? We tend to take for granted that states should have these territorial rights. This is just the way it is. We have territorial states, but of course, here in this conference, we are the people who are putting these things into question. Possession of land plays a central role in Kant's legal philosophy. So you have this idea of possessing land as being very, very important for his legal theory. And why is that? Kant argues that possessing land is the necessary condition for private property in objects, or possession of objects. So I would like to distinguish between fully fledged ownership and just possession of objects, having control and a certain claim to an external object. So let's talk about possession for now. So Kant thinks that possession of land is a condition for being able to possess objects. Now you may ask why. Why is possession of land so important? Well, there is an obvious argument out there, and this argument was made by Katrin Flickschul on her book. I can't remember the title now, but she has this one book about modern political theory and Kant. And the argument goes like this. In order to be able to enjoy what you have, the possession of the things you have, you need to have some control over the location of these objects. So unless there is some possession of land, some control of the land, you would not be able to enjoy what you have. So think about the example, for instance, you own a car, you are the possessor of that car, but somehow you have no control over the location of that car. Right? So every time you park your car in the morning, you go to your department, do some work, and by the time you leave, the car is still yours, it hasn't been stolen, but people can just move it around. So you would have to go and look for your car every time. Surprise, where is my car? And so on. So the idea is that even though you do not have possession of the streets on which your car is parked, someone has that control over that land, and you can enter some kind of agreements. There are some public agreements about where you are allowed to park your car in public areas, whether you have to pay a parking ticket, and so on. So the idea is that there is some agreement derived from some prior possession of land. And this is the condition for you to be able to determine the location of your stuff. And this is why also we tend to store our things within our own four walls. So the idea is that if we have control over our homes, we will also have a place in which we can have our possessions and determine how what we do with them and where they are. Now, I think this is an argument that has a lot to do with empirical conditions for the possibility of private property. And I think that Kant's point is a deeper one, is a metaphysical one. And it has to do with the priority of land, of possession of land, over possession of objects. So the metaphysical priority of possession of land. And why that? So the idea is that if you look at Kant's legal philosophy, space, the fact that we are embodied beings in space, that we can interact with each other, and that our actions can impact on each other, plays a huge role. So we have to conceive ourselves as being connected somehow to these things that occupy space. And of course, you can think of land as the largest space on which these movables are located. So the idea is that acquiring a piece of land gives you automatically the movables that are contained, that inhere on that land. Similarly to accidents inhering on the substance. So to acquire the land is to acquire the stuff on it, with it, right? So the whole pack comes with it. And what Kant wants to explain is how you derive these legal relations from that original acquisition. So the way you can explain acquired rights to objects. So someone first acquires that piece of land, and you can, of course, enter in agreements with other people can acquire that stuff on your land, and so it is possible to detach the movables from the land, from the first acquisition, but that is derived. This is the story. So first of all, the first acquisition of all, we have to assume that objects were acquired for a first time, and this will be acquisition of land. Right? So this is my point in complementation to this argument about control. Now, we can still ask, so why territorial rights, as opposed, for instance, mere private property in land? So we can imagine just individuals acquiring land in the world, and, you know, why should we grant states this jurisdiction over territory, or this idea that they have a territory? Now, first of all, it's important to see how Kant's story is different from his predecessors. So he often uses the terminology, but Kant Kantianizes everything, right? Even when he's dealing with the tradition, he reinterprets things. So you see the predecessor's argumentation. So if you look at Locke, if you look at Hobbes, you have this kind of prudential justification of the state, so why we should obey the state, and also why states should have the right, you know, to control territory. Well, if you look at Hobbes, this is clear. We have these desperate individuals dying of fear in the state of nature. It doesn't make sense to work on anything because it will be stolen, you know, you're always under danger. For Locke, it's a bit milder, the state of nature, but you still have this prudential view, right, that the state is there to protect. Thank you very much. And I have in mind a particularly interesting reading of Locke, Byte's interpretation of Locke, as territorial rights being very much based on property rights for Locke. So you have this idea that when individuals agree to submit to the state, this original contract, they also submit their possessions. So the duty to obey the state, according to Byte's reading of Locke, is something like, okay, so the territory, the reason why we have this jurisdiction is that we have given some of our property rights to the state, and the state will guarantee our interests in land in perpetuity. So whoever enters the territory will have to play by the rules of that territory. Right? So this is a form of protecting those interests in land. Now this is Byte. Now, for Kant, those ideas, this idea of interest, this idea of prudence or rational self-interest is not an option. And why this is not an option, there is an explanation for this, apart from the fact that, you know, oh, Kant is the ontologist. Look, there is a good reason for this. And the reason is that Kant wants to understand obligation. And he thinks that obligation has a specific character. If it is to be binding, it has to be necessary, it has to be universal. And human nature, particular interests, they cannot ground this universality. So how can we, is there a right to exclude others? Because after all, the territorial state has the right to control borders, has the right to control and to exclude, right? So for Kant, this comes, the right to exclude comes with an obligation. So it's not mere power that I'm here, you know, kicking out those who want to join. But the idea is that those excluded have an obligation to respect that acquisition, right? That territory. I will try to explain, so it's still very vaguely what this territory is supposed to be. So how to explain this obligation to respect borders? Because actually, if there is a right to exclude, there must be an obligation to respect what's going on, right? So it's a huge task to make sense of that question. Now, my argument is the following. So I'll argue that borders and the territorial rights of states must be assumed in Kant's framework not primarily to protect private property, although this is also a function, but that the function of the territorial state is in fact to satisfy a rational requirement. So what is the rational requirement? We need to use objects. So this is the question. We do not want to deny ourselves of the possibility of making use of stuff and having objects of choice. In other words, if we are going to have stuff that we can use for our purposes, we need some form of exclusionary use of objects. We need property. Right? So the question is, if private property, right, we have here liberal egalitarian legal theory, we want to explain how can that practice be compatible with the freedom of all, right? Who have equal rights and are being excluded. So the theory is an answer to that question. If private property, which conditions must be satisfied for this to be compatible with the equal freedom of all? This is the problem. Territorial states are part of the story, I will argue. So you need to have this territory, you need to have this public institution within that territory administering justice in this omnilateral way in order to satisfy that rational requirement of reciprocity. So this is the story. So it's not here individuals so scared of the state of nature, although there are some passages in the Doctrine of Right that suggest that. I think they're actually a rebuttal of Hobbes, so I will not talk about this now, but I have a paper on this if you are interested to read further on that reading. So the idea is the following. So what are these rational requirements that we are trying to implement, and why do we need that? The idea is the following. All possession of objects and future private property, future ownership, requires first acquisition. So at some stage, we must assume that there was a first acquisition of land, a division of the planet, right? The problem is the following. All acquisition for Kant is individual, individuals are the ones who have these rights to acquire, but unilateral acts, empirical acts, are not enough to impose an obligation on all others. So the picture is the following. Imagine in the state of nature, Alice arrives in an island and, there's no one there, and Alice puts her little flag, the Alician flag, okay, of the Alician Republic. And yay, I'm the first possessor. Now, what I am doing when I'm saying I'm acquiring this piece of land for the first time is something incredible. This means that I'm putting an obligation on all others. And this is not only my neighbors, I'm putting an obligation on all inhabitants of the planet to abstain from my possession. How is it possible that little Alice on her own produces such an incredible obligation, right? So this is the question. And for Kant, the solution, of course, is this. The picture that we want to leave is this picture in the state of nature of one individual against the other, right? So I tell you what my acquisition is, and this is my right, I tell you. And the other says, look, I will tell you what is right. I don't believe in your acquisition. I think you have too much. I think this is part of what I have. And we have a disagreement. So individuals do not have, according to my reading, the authority to impose obligations on each other. So it's a question not of power, not of force, but of authority. Authority, quis judicabit, who has the right to decide. Right? So territorial rights are only part of the problem. And this was the passage that I wanted to read with you. So this is a passage of the Doctrine of Right. So this is the work. This is the first part of the late Metaphysics of Morals. So this is very, very late stuff. Usually people are not acquainted with this part of Kant's work. And there has been a lot of prejudice against it. Less in German-speaking Kant scholarship, but more in the English-speaking scholarship. So this is the Doctrine of Right, and Kant is talking about the rights of states. And he asks a question. So the question is the following. Can the sovereign, Beherrscher, be regarded as the supreme proprietor, so this is the Obereigentümer of the land, or must he be regarded only as the one who has the supreme command over the people by law? So what is the question? Is this only jurisdictional rights over the people that the sovereign has? Or is it also private property in the territory? Okay? So let's have a look at what he has to say. And then he says what we already know. Look, land is the ultimate condition that makes possible to have external things. But all such rights must be derived from the suprema proprietor of it. And he calls the suprema proprietor Dominus Territorii. This supreme proprietorship is, however, only an idea of the civil union that serves to represent, in accordance with concepts of right, the necessary union of the private property of everyone within the people under a general public possessor. So that determination of the particular property of each is in accordance with the necessary formal principles of division of land, instead of with principles of aggregation, which proceed empirically from the parts to the whole. Now, this is a scary passage. I was hoping I would have it for you on the, but I will explain it to you, so don't worry. So the idea is the following. The state is there playing a role. It has the authority to assign to each individual what is theirs. Okay? But of course, the idea is that you already start with a division of land. So you have individual property in land, And the state will not redistribute, but the state will have the right to decide. In case of conflicts, the state has the authority, right? Or the effective right, as Rudolf put it. Now, why is that? Why do we need that? So Kant adds the following. So look, all private property should belong only to the people, taken distributively, not collectively. Right? So imagine a collection of individuals, and each one of them can be said to possess the land. The sovereign should never possess land, should never have private property in land, because that will turn the sovereign automatically into a private person. So the right to own property is already tied with the concept of being a private person. The sovereign must, if it is to play the role that it's supposed to play, not have private property, because it is there to decide. And in the case there is a private dispute between the sovereign, who is suddenly owner of land, and the people, who is going to decide? Right? So no private property. And then he says something very interesting. The second thing that he says is the following. He said, if the sovereign starts acquiring land, all right, it could end up with a scenario where all private individuals would end up as serfs. So he calls them glebe adscripti. So this kind of serfs that would be bound to the land. You would be deprived of the freedom to move around, to leave that place. So the state has this authority, right, to decide, and must remain without property. So the idea is that the state is playing some kind of unifying role. In order for individuals not to settle these conflicts themselves, you need this kind of institution that has a public character. So the public character consists in the representation of all, right? So you have that institution that lays down what is right, has the power to educate, and has the power to enforce. So this is taken away from individuals. That's why we need the state over private property, right? Now, as I was mentioning before, there are other accounts of Kantian accounts of territorial rights, and Anna Stiltz is one of those, a strong statist view of territorial rights. And according to her view, the role of states is to enforce justice, and states that have territorial rights are legitimate states, meaning states that are just. So she reads that in Kant. She thinks that this is what it is, just states. Now, her reading is not quite compatible with the text, because she seems to be interpreting just states in a very substantive way. So she's saying, look, a state that, does not recognize human rights, that does not have territorial rights. Or Venezuela doesn't have territorial rights. This is one example that she gives. You are not allowed to deprive people of their territory for other reasons, but this is not really a state that has territorial rights. Now, Kant's reading is much thinner than that. So the idea is that you have this public institution, and justice in this context is, of course, a more procedural kind of justice. So the state is playing this public function. It is not about a list of standards that you have, and then you go and tick the boxes, see if the state satisfies these conditions. There is in Kant's legal theory, of course, an ideal state that we ought to strive towards. This is the Republica Noumenon, but this state is nowhere realized. This is an ideal of a perfectly egalitarian, just state, but this is, it would not disqualify the fact that states are not the ideal republics, would not disqualify them from territorial rights. So this is not. It's not a correct reading of it. Now, still, we can ask, why do we need borders for this, right? We can still keep asking the question. So let us reflect a little bit about the nature of borders. Borders are contingent. So they emerge out of quite empirical contingent factors, such as, you know, sometimes you have geographic factors, a river that divides two places or some mountains. So there you kind of inclined to draw a natural border. Or just historical events, you know, someone got married to someone else in the Habsburger family, and then you have a border here now where you didn't have it, and so on. So these borders, the way borders emerge in the global landscape, is often also a result of bilateral agreements. So you have neighboring groups, and they recognize, okay, this belongs to me, I'm here, and you are there. Okay, guys, I'm looking at you, I'll leave you alone. We recognize your border, that's fine. But this is not binding to other parties that are not involved in these bilateral agreements, right? So this is all very contingent. Why should we respect this kind of arrangements? Now, there is one sense in which border seems to be necessary. And when I say necessary, I mean not because, you know, we need to live like this, but some more deeper consideration. And what do I mean by that? I think that Kant assumes in his theory as a version of the Lockean proviso. What is this? Well, he says, look, it's not his wording, but this is the way I put it. There cannot be kings and queens of vast space. So you imagine Columbus arriving in America with his little flag, and you see, I thereby declare that this whole continent belongs to Her Majesty, the Spanish whatever. Bling! I am, you know, the proprietor of all this territory. As we know, Locke assumed natural boundaries to acquisition in the state of nature, that is, what you can use, right? Kant doesn't go right for that, but he, for instance, he invokes Grotius, Mare Liberum, when he talks about, okay, so how do you define how much into the waters? So a state will have territorial rights, and then he mentions the cannons, the cannonballs. So how far the cannonballs will reach is your waters. So the idea is that, okay, let's take the principle of how far you can defend that territory as an indicator of the extent of your possession. So the idea is that we have a huge problem there determining the extent of individual acquisition, because, you know, people could declare themselves the masters of the universe, right? There must be a principle for saying, okay, that far it cannot go. It cannot be your acquisition. And this is for Kant the hardest problem of all, but we should not dismiss. So this cannonball story is one attempt to find a principle. But the implicit idea is that even though there is an acquisition of land, right, it is implicit a respect for the equal rights of others to acquire, even though that acquisition is not an equal distribution. So the principle of distribution that Kant is assuming there is first occupation. So if the land was unowned, you arrive, and somehow it is a reasonable, so there is no clear guideline, somehow it's a reasonable extension that you could be seen as using. So this is enough to ground your claim to it. So my point is that limits of acquisition, so if we are to take into account this version of the proviso, borders, I mean, the Germans even bad because Grenzen is the word for limits and for borders. So individual acquisition necessarily comes with borders, because it is not acquisition of the whole planet. It's always, acquisition is always a part of a determinate whole. So the determinate whole is the planet. So Kant is always thinking globally. Right? So it's a part of the planet, and it necessarily comes with borders, out of the very consideration that others must be left to acquire. Right? Okay. Okay, so we must, so my argument is the following. This scenario that I have described of the state as the supreme proprietor of land in regard to individual property owners is the story Kant has to tell us at the domestic level. We must distinguish between the two perspectives, international and the domestic. So at the domestic level, no property of land. Now, if you look at other passages, you have states in the international state of nature. So there are no juridical institutions above these states, and this is why there is war. But how do these states appear in this international arena in regard to each other, according to Kant? They are moral persons, according to Kant, due to the internal original agreement, due to their constitution. So out of respect for that union of the people internally, they appear as moral persons. And it looks like, so there is evidence to conclude that Kant assumes that in the international level, states are to be regarded as, actually, the nations they represent are to be regarded as the proprietors of land. So private property in the international arena, not in the domestic arena. So in the international domain, the nation, the peoples own the territory, right? So this is quite remarkable. Now, what I have to explain to you, for Kant, the problem of acquisition, so the problem of territory, he tries to treat this problem in the same way as he treats acquisition by individuals or by smaller groups. So he tries to treat it as only the same problem in a larger scale. Of course, there are further complications, because you can coerce individuals to enter a civil condition if they are in the lawless state of nature, but you cannot coerce states to enter a juridical condition. And of course, if you transfer the domestic scenario to the international arena, what you have is individuals defending their territory, their private property. This is what you have in the international arena. So what is the solution to that problem? A juridical institution that will unite the wills of those nations and will solve the disputes. So this is why war occurs, because this is the only means available in the international arena for solving disputes, right? So this is the problem that we have, but it is more complicated because you cannot coerce states out of respect for the internal constitution to join. So Kant's idea is the following. Ideally, you would have a world state. But as a matter of fact, we will not get rid so easily of territorial states. Out of respect for the original contract, it is highly probable that territorial states will still play a very strong role, although they have a duty to bring about these juridical international institutions. So the idea is that the whole globe should be under jurisdiction. So all relations between nations, between foreign individuals and foreign nations, stateless individuals, everyone should be regulated under these institutions, right? But because of states, because of this complication, because of this analogy, the world state is probably not an option. So the second best option, you would have a Völkerbund, some kind of voluntary association, federation of states who would agree to some kind of common international laws and would abide by them, right? So we can see that the current developments we have at international level as problematic as they are, they express this need for international regulation. Right? Now, so we have these territorial rights that ought to be respected, just like you ought to respect private property. But my argument is that there is a limitation to it. Because the very same principle that gives you a right to control territory is a principle that says that in the case of necessity, if you have nowhere to go, you ought to be admitted in a foreign territory. That gives you a right. So there is a right of safe haven. And what is this principle? This is common possession of the earth. So according to Kant, we can be thought to be in a community of land due to our spatial embodiment. And the way he constitutes this community, I like to call it a community malgré soi. So it is not that we kind of join this community, this hippie community of the earth, but rather that you can unite all spaces that people could occupy on the sphere, on the globe. You can unite them, and that sphere of the earth constitutes a community. We are stuck with each other. We can interact with each other. We can impact on each other, as our current global challenges very well illustrate. That constitutes the community of the earth. Because we have a right to be somewhere, right? This is due to the community of the earth. We have a right to settle down. We have a right to occupy land. We have a right to unite in a territory that is different, that has borders, that excludes other territories. But the very same principle, right, would undermine itself if, in the case of a necessity, persons who have nowhere to go would bar entrance. Because the right to be somewhere is what gives you territorial rights. If you go back all the normative chain of rights, right? And to deny entrance in the case of people who have the need to be admitted, right? This is not a right to settle, but this is a right to be admitted, right, in the case of need. So safe haven, as I said before, right? So there are some limitations there. These rights, these territorial rights, are not absolute. And I think that Kant's argumentation is very interesting because it is the very justification that gives you a right to the territory that commits you to admit people in it. Right? So these are people who are really being persecuted under danger. Right? So Kant's cosmopolitan right, I'll say this just very briefly, this right to visit. So the idea is that you have a right to offer yourself for interaction voluntarily. States retain the control of the territory. They have a say whether you should be allowed to come in or not. They should be friendly if your intent is friendly. But they actually have the say over the territory. Right? So this is cosmopolitan right. And the limitation, this is this right of safe haven that comes through the very principle. Right? And somewhere else in another paper are argued that cosmopolitan rights, in Kant's account, is his version of the right of necessity in Grotius and Pufendorf. So this is related to private property, and I think that Kant translates this into a right to be somewhere in case of need. So this is the right of necessity in Kant's account, right? Okay, so my point that this is the thing that the last thing that I will say, and the thing that I still need to work further. My view is the following, that territorial states in Kant's account are actually only allowed, and actually they only make sense and are required because there is an international state of nature. If we could imagine that we are overcoming this international state of nature, right? Borders would make less sense. So borders are there to protect private property, to protect individual freedom within the territory because there is lawlessness outside. between the relations. So imagine there is a territory here and there is a territory here, and their relations is unregulated. You need borders for that, right? So you need to assume your jurisdiction. So here's me, and you're not allowed to enter, and if we do not agree with what's going on, there is war or an international agreement. That would be nicer. But if we can slowly overcome the international state of nature, borders are much less important. Doesn't really matter so much, right? And I have the feeling that this has been exemplified to some extent in the European Union, right? So there's still, of course, people choose to live where their families are and so on, but borders, defending borders within the EU, lovely to be able to travel around, isn't it? So this is my point. Territorial rights are justified because of the international state of nature, and they are a necessary step, right, towards this juridification at cosmopolitan level. We may remain like this because, as I said, the world stage is not really an option. Right? So thank you very much for your attention.